r/legal advice. Specialitis says, my doc snuck in an expensive cancer screener in my lab work. I learned that she gets a commission. I feel tricked. Am I legally bound to this bill, or should I fight it? So I went to my doctor for my annual exam and asked for a pap and all the checks on my blood for hormones and health checks. After my pap, my doctor offered me a cancer screener from the company Grail. I asked if insurance covers it, and she said that I could make payments on it every month. I replied, I don't want it if my insurance isn't going to pay for it. She said that her lab assistant could help me with that information. The lab assistant who helped me told me that the doctor told her that I wanted the test. I told her that I don't want it if my insurance doesn't pay for it. She said, okay, and smiled before asking me to sign for several labs on my blood that the doctor ordered. The lab assistant told me that Grail would contact me about fees. I figured that this meant that they would let me know fees and information somehow to get this done. Later after time, I received an email with an attachment that I opened that had cancer screening results and a $900 bill. After contacting them, their local representative, the lab assistants, the lab they worked for, and then the doctor, I finally got answers. The representative from Grail told me that the doctor's office receives a commission for every test they conduct and reminds the lab technicians to ensure that they ask clients before conducting the test if they agree to receive it. I did not agree. Grail keeps sending bills and says that they can't do anything about the bill I now owe. My doctor told me that I signed paperwork to have the test done. She remembers that I had initially told her that I wanted all the checks on my blood and that I can surely pay $30 a month for this test. I told her that I had told 2 medical professionals that I did not want the test and that I signed for my blood tests, not that one. I also told her that the lab assistant did not explain anything to me and that I didn't want another medical bill because I have other medical bills I pay every month. She said that no other client has complained and that all her clients are fully explained the test. I told her that I hadn't explained anything and that I must have slipped through her process. She let me know that I signed for it and that I was responsible for it. I feel tricked. Is she correct? I thought about filing with a small claims court. Does anyone know if I have a case that could win to give her the responsibility for this? Magica Mr. Coolslet says, I'm a physician and I would report this physician to their medical board. Pretty sure getting kickbacks/commissions for tests ordered is against the law and completely unethical. I would also report it to your insurance because they have a contract with your physician. When you report it, ask to file a formal grievance or formal complaint. This is so far beyond the pale. Todo3 says, also a physician, which is why I highly doubt the story. Namely the representative from Grail confirming the kickback. You're right, a kickback for tests is illegal. That is why there is no way in hell the company would be stupid enough to do it in an illegal tit-for-tat way as a matter of policy. If they are engaging in illegal practices, I then doubt their customer service rep will disclose that to you over the phone. More likely they or you misunderstood. More likely scenario in my view, doctor orders a test he likes, unsure of if insurance will cover it, because he likes it, or believes in it, whether correctly or incorrectly. I believe incorrectly in this space. He assumes the lab or the company or someone will verify coverage first. No one does. You get stuck with the bill. By all means dispute the charge, get representation, get the fee waived if you can, but I doubt you stumbled upon a conspiracy of illegal malfeasance. Lulabelle724 says, agree. I've worked in genetics labs for years and currently work for one that has a similar-ish product to Grail. There is absolutely no way providers are getting kickbacks for ordering the test, and I also highly doubt that a phone rep would have said such a thing. Something isn't adding up. Haunting Seed 2084 says, now, but I do work for an insurance company. You can also see about filing a complaint about the doctor with your insurance, and if the test was billed to your insurance and denied, I would also suggest filing a grievance essentially stating all of this information. Even if it wasn't billed, you can try submitting for a reimbursement, depending on your policy, and if that is denied, or even if it only pays at insurance rates, file a grievance on that as well. It won't make the doctor responsible for the costs, but could potentially remove your responsibility. r/legal advice. Mysterious Wind 8882 says, my school's prom changed the rules to attending after selling hundreds of tickets, no refunds. My school prom changed the rules of attending after most of the students already bought their tickets. The new rules were that you could not have more than 4 absences in the school year and 12 tardies. Almost everybody cannot attend now. The students are mad and the school is saying no refunds to tickets already sold. Tickets were $65 each and $100 for couples. Over 240 tickets have been sold prior to the new rules. Is there any legal action our parents can take? Delicious Medium 944 says, there is certainly a cause of action for a lawsuit if the rules were changed after purchase with no option for refund. They are taking money without offering the promised service or a refund. The dollar amount of damages are pretty low though, but with so many people affected, someone might be willing to take the case. I would suggest getting together a list of all the people affected by the rule change, then contacting some of the more vocally mad parents with that list, to bring to an attorney. They might have to shop around to find a lawyer who would take the case, but if you want justice from the school district on this, it's the only way. I imagine if the district are contacted by an attorney, they'll realize their mistake once it's explained. They could be liable and settle for a refund plus the attorney's fees back. Source, am attorney in Illinois. Clint says, not necessarily so small. Dress that isn't likely to be worn elsewhere. Tux rental, deposit on limo rental. Easily several $100/couple. Some of it depends on how much notice was given. I can see why the school doesn't want to give refunds because of money spent on the venue, but that isn't the kid's problem. Sconagrower says, at least in Isle, could you sue a school district in small claims court? Because this situation is exactly what small claims is for, right? A parent evaluation says, where? Public or private? Almost everybody cannot attend now. How much is almost everybody? 230 out of 240 people. But this is something for your parents to take up, if need be. Kids can't sue, and this isn't enough to sue over. And in theory at least, if someone has a ticket, they should be allowed in, correct? How will the parents at the door know how many tardies you have? But discuss that with your parents as well. Mysterious Wind 8882 says, public school. I wouldn't know an exact number, but I know almost my whole grade has more than 30 tardies, as they haven't really enforced tardies until today. It is probably 3/4 of the people with prom tickets. You also have not been allowed to fail a single class in the school year. In my school the previous years it has been school monitors at the doors checking you in with your student ID number, all except for students from other schools. Miss Amy Ames says, for a public school, the next step would be to go above your school admin and have your parents complain to the school board. Definitely contact the member who was elected to represent your area. Have all of your friends' parents complain to the school board as well. r/legal advice. Nanotech says, Bowers told me I can't accept a job from their client's client company due to their non-compete agreement. I never signed a non-compete agreement. I work for a company whose client is X and X company has client Y. The company I work for told me that I would have to wait 1 year to be able to accept an offer from X or Y company, even though my contract actually doesn't state a non-compete agreement. It just says that I can't work another job simultaneously. The hours representative I spoke with told me it's due to the contract they have with their client and the non-compete agreement, so I was deterred from looking further. Would this be true in this scenario? When I asked why I was never told of this requirement during my interview or the hiring process, the hours representative said that it is common sense and that all contractors in New York are aware of this. I have looked through every document I signed, and I do not see anything that mentions a 1-year clause or a non-compete agreement. Thank you in advance to anyone that took the time to read this / replied to this. Push Through the Pain says, I think what they are saying is that your employer and their client have an on-hire policy between them. The client is likely unable to hire you. Vegan Bull Gang says, I believe for this to have teeth there would have to be an agreed upon remedy, usually a finding fee / hiring fee contract that just says I agree not to do X, but sets no remedy if you do X anyway, is not a very strong contract. Next Negotiation 407 says, per an article I googled, the banning of non-compete clauses would not take effect until August, but there are expected legal challenges that would most likely delay the implementation. I know, but can you ask to actually see the non-compete documentation? Nanotech says, they are supposed to reach out to me in 2 to 3 business days, but when they do I will ask them about it. Echinus Rosso says, not sure why it hasn't been pointed out already, but a non-hire agreement doesn't create any liability for you. Obviously the company may be less than inclined to extend an offer, but they're the one with an agreement, so you wouldn't be violating anything by accepting. That Kryptonian says, it's not because of what you signed. It may be due to an NDA they both have for non-solicitation. This is mainly to protect the confidential information. OK Astronaut 213 says, did ours say you signed this non-compete, or is this an agreement they have with the other company? Has the latter actually made you an offer? If so, it's weird they didn't mention it while you were interviewing with them. Nuenter 18 says, this is not a non-compete. This is a non-solicitation agreement between Op's employer and their client. It's not binding on Op, but in practice that doesn't matter because the client isn't going to want to, usually, violate it. Which means, typically, the client isn't going to knowingly make an offer of employment, or if they do, once Op's employer notifies them of the employment relationship, the offer may be withdrawn. That's all for this video. Thank you for watching. Please subscribe.